Good morning, guys. My name is Shiven Asthana. I am a second year law student from WIPS IP Delhi. So today I'll be talking about writs. So what are writs? I'll be explaining with two definitions. The term writ refers to a formal legal document that orders a person or entity to perform or to cease performing a specific action or deed. Writs are drafted by the judges, courts, or other entities that have administrative or judicial jurisdiction. The other definition is writs are a firm written order from the Supreme Court or High Court that commands constitutional remedies for Indian citizens against the violation of their fundamental rights under Article 13, 14, 15. Article 32 in the Indian Constitution deals with the constitutional remedies that an Indian citizen can seek from the Supreme Court and High Court against the violation of his or her fundamental rights. The same article gives the Supreme Court power to issue writs under the enforcement of rights, whereas the High Court has the same power under Article 226. So there are five types of writs, namely habeas corpus, mandamus, certiorari, quo warranto, and prohibition. I repeat, habeas corpus, mandamus, certiorari, quo warranto, and prohibition. So what is habeas corpus? The Latin meaning of the word habeas corpus is to present the body. The writ is used to enforce the fundamental right of an individual liberty against unlawful detention. Through habeas corpus, Supreme Court or High Court orders one person who has arrested another person to bring the body of the latter before the court. There was a landmark judgment of ADM Jabalpur versus Shivkan Shukla, which is also called as the habeas corpus case. Facts about habeas corpus in India. The Supreme Court or High Court can issue the writ against both private and public authorities. Habeas corpus cannot be issued in the following cases. Firstly, when the detention is lawful, when the proceeding is for contempt of court or legislature, detention is by the competent court, detention is outside the jurisdiction of the court. Second, mandamus. The literal meaning of this writ is we command. This writ is used by the court to order the public official who has failed to perform his duty or refused to do his duty to resume his work. Besides public official, mandamus can be issued against any public body, a corporation, an inferior court, tribunal, or government for the same purpose. Mandamus cannot be issued in the following cases. First, to enforce departmental instruction that does not possess any statutory force. Second, to order someone to work when the kind of work is discretionary and not mandatory. Thirdly, to enforce a contractual obligation. Fourth, or against someone who are acting under their judicial capacity, just like judges. Third is prohibition. The literal meaning of prohibition is to forbid. A court that is in a higher position issues a prohibition writ against a court that is lower in position to prevent the latter from exceeding its jurisdiction or uprising a jurisdiction that it does not possess. It directs inactivity. Facts about prohibition in India. Writ of prohibition can only be issued against judicial and quasi-judicial authorities. It can't be issued against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari. Fourth, certiorari. A writ of certiorari or a writ in the nature of certiorari can only be issued by the Supreme Court under Article 32 and a High Court under Article 226 to direct inferior courts, tribunals, or authorities to transmit the court the record of proceedings disposed of or pending therein for scrutiny and, if necessary, for squashing the same. A writ of certiorari or a writ in the nature of certiorari is basically this. And lastly, but writ of certiorari can never be issued to call for the record or papers and proceedings of an act or ordinance and for quashing such an act or ordinance. Last is quo warranto. The term quo warranto means what is your authority. The writ of quo warranto is used to judicially control executive action in the matter of making appointments to public offices under relevant statutory provisions. The writ is also used to protect citizens from the holder of a public office to which he has no right. The writ calls upon the holder of a public office to show the court under what authority he is holding the office in question. These were the 5 writs. Thank you.